I am the parliamentary draftsman. I compose the country's laws, and of half the litigation, I am undoubtedly the cause. I employ a kind of English which is hard to understand. Though the purists do not like it, all the lawyers think it's a grant. It runs into many more lines, but then I would like to stop here. But this poem is basically trying to tell you that the law is a very cliché subject, and as a lawyer we still call it very easy subject, but when people start reading it, it is really very difficult to understand. As lawyers, we also find sometimes so difficult to understand and to interpret the law. Today's discussion on the 156.3 CRPC is a very crucial one. It has not been explicitly, I would say briefly, it has been said, but not explicitly explained, not clearly very explained. You will find 3-4 lines under 156.3 CRPC, and under that you have to interpret the law. Now there are various judgments, but then 156.3 is the basic thing. And before we go to 156.3 of CRPC, let's understand from the section 154 that how the criminal law is put into motion. See, anybody in our country can go to the police station and put the criminal law into motion and file a complaint, which will culminate into cognizable or non-cognizable offense. If it's a cognizable offense, FIR is lodged, that is first information report. Now, section 154 is very clear that the officer or a station house officer, SHO, who is at the police station, has to, if he gets information about the cognizable offense, it is his duty to register the same. But this has not been the experience of everybody, including all the lawyers here. That when we go to police station, for some reason, if the officer feels that this is not an offense where I have to register, he may call it a civil matter, he may divide it, or I would say classify it as being a non-cognizable offense, or you may call it a matrimonial dispute, try to go to the family court. But there are matters which requires to be registered being a cognizable offense. Now, so 154 CRPC, if we look into it, there is no word first has been mentioned anywhere in the law. It is just the information given to the police station. Now, police officer may not register it. Now, what happens when police do not register it? What happens? Whatever, all the people rush to the court and try to file a complaint under section 156.3 CRPC, a private complaint along with an application under 156.3 CRPC, which says that the magistrate can order for registering FIR and also direct for investigation of a cognizable offense if he finds a substance in your matter and the material you provide while making an application 156.3 CRPC. But what happens? Normally 156.3 CRPC, the court grants, or I would say allows your application only when you provide a good material, that there is an evidence. But before we go to that evidence things, I would like to tell all of you, there is a prerequisites of some of the things we have to do. Now, what is the prerequisites? There are some judgment also we are going to discuss, which is summarized that what are the guidelines to be done, what are the precautions we have to do. Simply, I would put it in my layman language that whenever you go to police, please state, don't state your complaint. Normally, what happens, we just orally state our complaint. Now, when you're saying that your complaint has to be registered, it should be written, because the police officer, one thing I would say from the experience of Mumbai, Delhi metropolitan, 2 cities where I have stayed, the police are like burdened with lot of matters, lot of police stations, and there is a lot of work, pendency also in the court. So they may not have time to listen you properly. So always go with a written complaint. That will help you to make them understand your complaint and they can read fast, you can save time. So if your written complaint is that they may just put it to dispatch and call you back later. But if you start saying orally state the complaint, he or she, the police officer may not have really the time to understand your complaint and to have that kind of patience unless and until there is some blood oozing out from your body or there is some patient with you who has to be taken to the hospital, and it is too difficult to get the medical certificate immediately. In such type of cases, or all the more I would say, you try to take your complaint in writing and get it stamped by the dispatch department of the police station, and they may call you later if it is not urgent. If it is urgent, you can always request the police officer there that kindly hear me out or give me some time at least so I can tell you what is my facts of the case, and FIR need to be registered. Now, after this is over, what happens that if he or she, the police officer may not find a substance in your matter, and they may say, they may simply register as an NC, that is non-cognizable offense, and they will give you a chit where they said you are advised to go if you wish to go ahead with your complaint. Now here you are disappointed that your complaint is not registered. Now after this, the another option is to go to the senior police officers, that is the superintendent of police. Now here I would like to read this section 154. If you go to the 154.3 CRPC, see, there's a difference between 156.3 CRPC and 154.3 CRPC. Any person aggrieved by refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police. See, the word is in writing and by post to the superintendent of police, that's the SP concerned, who if satisfied that such information discloses the commission of a cognizable offense, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the matter provided by this code, and such officer shall have all the powers of an officer in charge of the police station in relation to that offense. Now see, 154.3 is equally that important. So if the officer refuses to register a complaint, you can always approach the higher police officer, that is superintendent of police, by writing and by post. And if you can go directly to the SP office, which is near to your place, you can always approach in person to his PA or the officers who are below him and give your complaint and get it dispatched again. So before we go to 156.3 CRPC to the court directly, asking the magistrate court or the court of magistrate where you are located, where your police station comes under the nearest magistrate court, and file a private application is before that. I would say always take this route, that is 154.3 CRPC. And if the SP thereafter do not find any substance that matter, and from there also you get disappointment, then go to the court under section 156.3 CRPC. This is what the basic thing you should all of you do. Now we live in metropolitan cities. Here we can approach the DCP of the concerned area. So that is the Deputy Commissioner of Police. So this is very important that 154.3 also has to be read before we go for 156.3 CRPC. Now this is like a representation or I will call prerequisites of any FIR to be lodged before or we go to directly to the court. And the today's session is all about that. Instead of going directly to the court, we should always take this route. And if the Honorable Magistrate Court, which peruse your complaint, and the Honorable Magistrate asks you that whether you have taken this route under section 154.3, and if you are unable to tell that, no, we have not taken, he may refuse to entertain your complaint. Always remember this. So before we go to 156.3 CRPC, we should always approach the local police station. If local police station refuses, then under 154.3 CRPC, approach the nearest, that is SP of your area, or the Deputy Commissioner of Police. Now, once this is over, the next step is go to the court. Even SP also refuses to register a complaint. Then you have only one thing, that is 156(3) CRPC. Now, under 156(3) CRPC, what is the format and all that? The title of today's session I have kept is application under section 156. Now, it is an application, it is not a complaint. See, complaint is always a private complaint that may come under 200 and 202 of the CRPC, where you have to go for inquiry and investigation. When you are approaching the court under section 156(3) CRPC, you are trying to tell the court there is a cognizable offense which has taken place, and the police is not ready to register the complaint. In this case, I am requesting this honorable court to take this cognizance of this application under section 156(3) CRPC and direct the police to register an FIR and also to investigate further. Now, see, 156(3) CRPC, is it mandatory that the judge may give you the order to register an FIR to the police? It's not mandatory, it's not necessary. At least the section do not say that. It simply says that the magistrate court has a power under section 190 CRPC that he or she, the presiding officer, can direct the police to investigate. Now, when the police is directed, the only option left to the police officer to register the FIR and then investigate. Now, what charge sheet he is going to file and what investigation he is going to do is another thing. But here, the under 156(3) CRPC, magistrate may order for registration of FIR or may not. He may simply give the order to investigate the offense. So this is very important that when you go for before the court, always make out a case, and your this complaint along with the application of 156(3) should disclose some kind of material which convinces the court that there is a cognizable offense which has taken place. There is a evidence which is available. There are some witnesses list also you can give. That these are the witnesses who are there present at the scene of offense, or they are aware about the what has had taken. There may be documents also which you can annex with your 156(3) CRPC application. So it is not complaint. Always remember, there is a difference between complaint and application. The word used under section 156(3) CRPC is the application. It's not complaint. The word is not. Complaint has got a different meaning in the law. It may be a private complaint also. Of course, when you go to the police station, you register a complaint. But when you go to the court, it will be simply a application under section 156(3) CRPC. Now, here I would like to discuss one very interesting case, Sakiri Vasu versus State of UP of the Supreme Court. Now, this is very interesting case. What happened here? This appellant, the petitioner's son was a major in the army, and there was some report of the army authorities that he committed a suicide. But this person, being a father, he was not convinced. And there was also, he has come to know there were some corruption charges against the other officers, and which his son was aware, and he was under the impression that my son has been murdered by some other officers. So he tried to lodge a complaint, which was not allowed, and he went to the, of course, when no FIR was lodged, under 226, he approached the Allahabad High Court. Now here Allahabad High Court said that you cannot ask the CBI inquiry because the proper forum before you is to go before the police authorities, register an FIR. If they are not listening to you, go to the magistrate court. He was asking CBI inquiry or CID inquiry for his son's death. Now it was not allowed. Even Allahabad High Court did not give the order in his favor. He approached the Supreme Court. Supreme Court very clearly said that when you have an alternate remedy, you have a remedy under 154(3) to approach the SP of local SP if your police station is not listening to you. you can approach the magistrate court under section 156(3) CRPC. And thereafter, if you are if you have even the magistrate court do not listen to you, you can go into revision before the session court, thereafter high court and the Supreme Court. So if alternate remedies available to you, then you cannot approach directly to the high court or Supreme Court. So the alternate remedy is very important part of the our legal practice. We have to satisfy court that why we have not taken the alternate remedy. Now there are judgment which even says just because there is an alternate remedy available, it does not put a bar to under section under article 220 say that you cannot come directly. But the court is bound to ask you this question unless the matter is of exceptional nature. So always remember that whenever there is a remedy available to you, kindly go through this procedure which is given in this CRPC. Now in Sakiri Vasu's case, he did go to up to Supreme Court, but according to his judgment, the Supreme Court said that you have the alternate remedy, approach the local courts or the local police station, then come step by step. So this judgment, I would say landmark judgment, it has been cited to my knowledge more than 10,000 times. So from academic nature also kindly try to read this. Now another judgment I would like to take all of you is from Bombay High Court, that is of Pandharinath Narayan Patil versus State of Maharashtra, that is of 2015, very recent one. Now in this judgment, there was some complaint filed against the police officer, and the magistrate court under section 156(3) CRPC order for registering FIR against the police officer. Now this police officer approached the Bombay High Court here, and the Bombay High Court very rightly said that under 156(3) CRPC, the magistrate court cannot mechanically just take the cognizance and order to register an FIR. Another point which was raised in this matter was that these police officers being the public officers, public servant, so you also have to take sanctions. So always remember, whenever you are filing a complaint, kindly check that whether sanction is required. Then secondly, have you approached the local police station, and have you disclose everything before the magistrate court, the material available with you. Now here what happened, when this matter went to the magistrate court, the magistrate court mechanically has ordered to register an FIR against this police officer. Now when this what happened, the material he has put before the local magistrate court was that he has written to the President of India, to the chief ministers, to the Commissioner of Police, various places he has complained. Now this kind and this style of complaining is not tenable under law, because sometimes when client comes to us, he says complain to the Commissioner of Police, complain to the President of India, complain to the Chief Minister, complain to the Home Minister. See, in law, I have never found at least such kind of complaint procedure. What is the procedure is explicitly, properly, clearly whatever words in briefly also if is spoken, is clearly spoken in the 154(3) CRPC and section 156(3) CRPC. So whenever you are putting a material before the magistrate court for having a direction for investigation and for registering an FIR of cognizant offense, try always to put up a material, documents, witnesses list properly, and a complaint duly given to the local police station, that is SHO or inspector, that is the local complaint officer, senior inspector in Mumbai and Delhi, I would say metropolitan cities, or the SP or the DCP, and thereafter you rush to the court. If you rush directly to the court, it is not going to happen. You may be lucky sometime, but then always understand the accused also has got a remedy under the criminal law to approach the higher courts and get your complaint FIR quashed. So in Pandhari, exactly the same thing happened, because there was no enough material and there was no sanction. 2 points were raised. Now, very important, another judgment I would like to share with all of you from the Delhi High Court. Now this is Shubhakaran Luharuka versus State of Delhi. Of course, it is from Delhi High Court. I'll go to para 52. It actually summarizes what I have said till now. This is para 52. Now, what is for the guidance of subordinate courts? The procedure to be followed while dealing with an application under section 156(3) of the code is summarized as under. See, the word used is application, not a complaint. Complaint is a different thing. You have to go for 200 and 202 CRPC. That is a different thing. Now, first one, whenever a magistrate is called upon to pass orders under section 156(3) of the code, at the outset, the magistrate should ensure that before coming to the court, the complainant did approach the police officer in charge of the police station having jurisdiction over the area for recording the information available with him, disclosing the commission of a cognizable offense by the persons arraigned as an accused in the complaint. It should also be examined what action was taken by SHO, that is the station house officer, or even by the senior officer of the police. In Mumbai, we have a senior inspector. When approached by the complainant under section 154(3) of the code. See, the 154(3) is also mentioned here. Now, second point is here, the magistrate should then form his own opinion whether the facts mentioned in the complaint disclose commission of a cognizable offense. Now, here the complaint means you are going to enclose that complaint which you have already given to dispatch department of the police by the accused person arraigned as in the complaint, which can be tried in his jurisdiction. He should also satisfy himself about the need for the investigation by the police in the matter, a preliminary inquiry, as this is permissible even by an SHO. And if no such inquiry has been done by the SHO, then it is all the more necessary for the magistrate to consider all these factors. For that purpose, the magistrate must apply his mind, and such application of mind should be reflected in the order passed by him. Now, here from the judgment, we can make out that it is said that he cannot mechanically just pass an order. It should be reflected in the order. That why he wants that police should register a complaint. Now, upon a preliminary satisfaction, unless there are exceptional circumstances to be recorded in writing, a status report by the police is to be called for before passing final orders. The magistrate, when approached with a complaint under section 200 of the code, should invariably proceed under chapter 15 by taking cognizance of the complaint, recording evidence, and then deciding the question of issuance of process. That is for summons matter to the accused. In that case also, the magistrate is fully entitled to postpone the process if it is felt that there is a necessity to call for a police report under section 202 of the code. Completely they have mentioned in this judgment of the Delhi High Court. Now, fourth one is, of course, it is open to the magistrate to proceed under chapter 12 of the code when an application under section 156(3) of the code is also filed along with the complaint under section 200 of the code if the magistrate decides not to take cognizance of the complaint. However, in that case, the magistrate, before passing any order to proceed under chapter 12, should not only satisfy himself about the prerequisites as aforesaid. Prerequisites, these are the prerequisites. But additionally, he should also be satisfied that it is necessary to direct police investigation in the matter for collection of evidence, which is neither in the possession of the complainant nor can be produced by the witnesses on being summoned by the court at the instance of the complainant. And the matter is such which calls for investigation by a state agency, that may be CID or police department or CBI. The magistrate must pass an order giving cogent reason as to why he intends to proceed under chapter 12 instead of chapter 15 of the code. See, this judgment clearly says that, or of course, I would say the judgment clearly guides us that before we go to the code directly to apply for under section 156(3) CrPC for lodging an FIR for registering FIR. These are the precautions we should take, because before, if we fail under 156(3) CrPC, there will not be a remedy for us to come to the police station again. Then we can't come back. Once the court refuses to register, the only remedy to go before the session court by way of revision and then go to High Court and Supreme Court. So please